Good morning, everyone. It is 11:01, so we will get started. My name is Becky Allen, and I'm with the Governor's Office of Crime Prevention, Youth and Victim Services. And this webinar came out of a work group focused on access to benefits for immigrant survivors within our office. And so we are pleased to have three speakers with us today to present on UNT visa certification for immigrant victims of crime and trafficking in Maryland. We have Leslie Orloff, with the National Immigrant Women's Advocacy Project at American University. We have Deepa Bijporia. She is a managing attorney with IUDA. And then we have Commander Giovanni Valiz. He is retired from the Minneapolis Police Department. I just want to let everyone know that this webinar will be recorded, and we will share it with all of the attendees following. And then there will also be a website where we're going to post the recording as well as some other resources discussed during the webinar. If you do need captioning, at the bottom of your Zoom screen, you should have the options for that. And we do want to let you know that questions will be addressed as they come in through this webinar. And so please utilize the chat function for questions. And like I said, we won't wait till the end for questions. So if you do have a question, please pop that in the chat and we'll get it addressed. So we have a lot to cover today, so I'll pass it along to Leslie and we'll get started.
Welcome. Wonderful to talk to you all. My name is Leslie Orloff. I direct NIWAP at American University, Washington College of Law. I am a family lawyer, but was actually involved in I was in the room doing the drafting of the T and the U visa, as well as VAWA self-petitions over the years. And so I'm really excited to be here. Just wanted to let you know that my participation in this webinar is funded by the Office on Violence Against Women. And what you hear today will be the opinions of the speakers, not necessarily of the event. As we get started, I want to tell you a little bit about NIWAP and the technical assistance and training we provide. Basically, we provide training and technical assistance. So you can call us if you're working on a case and you have questions. We have a team of both advocates and attorneys that can help answering, but we also have law enforcement faculty like Commander Valiz, who's with us today, prosecution faculty and judicial faculty who can help us answer any of your questions. We specialize in technical assistance for immigrant survivors under immigration law, public benefits laws, family laws, language access laws. Pretty much you name it, we can help you try to figure it out or get you to the right person. Next slide, please. We also host communities of practice, which are peer-to-peer learning opportunities. So if you're a family lawyer, you can join together with other family lawyers, and we do monthly webinar sessions and discussions for them. Victim advocates, we have a victim advocate community of practice. For systems-based victim advocates, law enforcement, and prosecutors, we have a community of practice for them. And any of you who are working with judges who you think might want to learn from other judges around the country about how to better serve immigrant victims, please refer the judges you work with to our National Judicial Network. Next slide.
Good morning, everybody. I'm so excited to be here. My name is Deepa Bijporia, and I'm the managing immigration attorney at IUDA's Maryland office. I want to just start out with that I have a cold, so I might be coughing and my voice is a little hoarse, but I'm really excited to chat with you today about immigration protections for survivors. So IUDA is a nonprofit organization with a holistic model that provides both legal, social, and language access services to low-income immigrants in the Washington, D.C., Maryland, and Virginia region. And we've served, for 50 years, served over 150,000 low-income immigrants. Next slide. So let's start out with a poll, which is always fun. We want to know who's with us today. Please check the box that best describes you when the poll pops up.
All right, we have about half the people answering. So I'll give it another 5 seconds or so. All
And it
right.
looks like for the others, somebody's mentioned child welfare in
Yep.
Maryland.
All right, I'm gonna end the poll and show the results.
So we have about 50%, go ahead. 50% of us are victim advocates or coalition staff, about 4% family lawyers, a couple of people from child welfare, about 17% said other, the governor's office on crime prevention. And we have about 21% that are working in law enforcement, prosecutors, and victim witness staff in those offices. Excellent. And we've got attorney, criminal attorney as well. So good mix of people. Back to you,
Next slide.
Deepa.
Next slide. So we've got a jam-packed presentation today, and we wanted to highlight what the learning objectives are. By the end of this training, you'll be better able to screen survivors for UNT visa, protections under the Violence Against Women's Act, and special immigrant juvenile status, implement best practices for obtaining UNT visa certifications, build good working relationships with certifying agencies, and be able to use NIWAP's benefit tools to look up how immigration relief options impact access to public benefits in Maryland. Next slide. It's another poll. Have you assisted survivors who are applying for these benefits?
All right, we have about half that have answered. I don't see much movement, so I'm gonna end the poll.
A lot of U visas, which is not surprising given who's attending today. I'm glad to see a lot of T visa because I think for a lot of different agencies, both legal and non-legal, T visas can be hard to identify. And I see a lot of SIJ as well. I call it SIJ as an immigration attorney, the special immigrant juvenile status. So thank you for sharing that. I'll turn it over to Leslie now.
Yeah, and I'm happy to see about 25% self-petitions as well. So that's very exciting. And from the data, it looks like some of you are familiar with this. There may be others of you that are maybe newer to this work or maybe familiar with the U visa, but less familiar with SIJS, etc. Next slide, please, or next two slides, please. So next slide, please. What we're going to do just to get started is one of the things we had been, so we do a lot of this work nationally. And one of the things we want to be sure of when we're working with immigrant survivors is that we're not missing legal options that they're eligible for. And sometimes, especially since that how long it takes to actually get work authorization or the visa under each of the programs varies dramatically, and as does benefits access by program, we really want to kind of start off by showing you how easy it is to identify and give you some tools about how to screen and figure out which of the forms of immigration relief an immigrant survivor you may be working with is eligible for. So we're going to do I'm going to go through this fairly quickly, and we're going to do a little hypothetical case just to make sure we're all on the same basis in understanding what these different remedies are. This is an updated new shield from the Department of Homeland Security. You will have it in the materials that we're going to be distributing on the website. And what's really cool about it is you see all these links. They link to the USCIS webpage on that topic. The round circles link to the latest forms. So it's a very good screening tool. And today we're really going to be focusing on T visas, U visas, and talk a little bit about VAWA self-petitions and SIJ. Many of you will be working with people with pending asylum applications, but of the 5 remedies you see here, the lowest success rate are asylees. And so asylum applicants should always be screened for victimization that could lead to a T or a U or an SIJ case. And also because newer immigrants to this country tend to be targets for crime victimization. So somebody who enters only with an asylum claim may then suffer a sexual assault or child abuse or domestic violence, or they may end up trafficked and have more immigration options available. So next slide, please. So the way I like to think about it is if any of these things happen to your client, they're eligible for immigration. So if you're working with a victim of any of these criminal activities, this is basically a combination of VAWA, the U visa, and SIJ, like all in one place as a checklist for you. But if any of these are happening, they will qualify for one or more forms of immigration. And so let's just quickly go through about how you can tell those apart. Next slide, please. So the VAWA self-petition, it was created for abused spouses and children of U.S. citizens and lawful permanent residents. It also it offers help to current spouses, former spouses within 2 years of divorce, children, and stepchildren. So this immigration law treats stepchildren fully like children, not like they're treated in the family courts. So there's protection for stepchildren. In addition, this form of relief protects abused parents when the abuser is their over 21-year-old citizen son or daughter. And so that's how you recognize a VAWA self-petition, when the abuser is a U.S. citizen or lawful permanent resident and they have one of these family relationships. Next slide, please. The VAWA self-petition generally is a petition that the victim files. Some of you, however, may encounter the same groups of people I was just talking about, the predominantly abused spouses and children, or stepchildren of U.S. citizens and lawful permanent residents, could also be cases where the abuser filed for immigration status for their spouse. And the way I think about this is, some of you, if you're ever working with a victim and they show you they have a legal permission to be in the United States, and they show you a green card, which may not be green. I don't know what color they are, Deepa, right now, but it changes. And that card ends 2 years after it was issued. If you see that, then this will be a victim who is likely eligible, if they're abused, for a battered spouse waiver, because their spouse filed papers for them and they think they have to stay with their spouse for 2 years and what the battered spouse waiver does is allow them to leave that marriage earlier and to do it confidentially without and get their full green card without their husband's or wives' cooperation. What color are they, Deepa, right now? You know?
I think they're actually green again.
Oh, okay.
It's just funny. For a while they were white, like a white pinkish background.
Right.
But now I think they're greenish tinged, but I haven't seen. I'd
Okay.
have to double check.
No problem. Next slide, please. So then there's something called special immigrant juvenile status. And many people think of this as primarily a form of relief for children recently entering the country from the U.S. from other countries who were abused, abandoned, or neglected by one of their parents abroad. That is in fact true, but actually SIJS can help any child abused, abandoned, or neglected by their parent anywhere in the world, including child abuse, neglect, or abandonment occurring in Maryland. So it's important to understand, like, all of the cases where you might have domestic violence and child abuse happening at once in Maryland, if the perpetrator of the child abuse is the child's father, then the child would also qualify, in addition to a VAWA self-petition or a U visa or a T visa, might also qualify for SIJS. Next slide, please. So the U visa is like, I kind of think about it as a broader catch-all. So we've been talking about the other three remedies I've talked about so far really are domestic violence, child abuse, child neglect, and child abandonment. Spouse abuse, partner abuse, spouse abuse. But that's not everybody we see. So the U visa was created to cover a broad list of criminal activities and for people that have been involved. So basically, everything I've talked about so far, the VAWA self-petition, the battered spouse waiver, and SIJ, there's no quantity of abuse that has to have been suffered. U visas required substantial physical or mental abuse. In addition, the first remedies don't require that they have to have come forward to a government agency and done anything. U visa requires that somebody has been, is being, or is likely to be involved in either the detection or the investigation or the prosecution or conviction or sentencing of the criminal activity. And so this helps immigrant victims of sexual assault, domestic violence, stalking, murder, manslaughter, felonious assault, kidnapping, human trafficking, a whole broad range of criminal activities. And lastly, next slide, is there's a T visa, which is specifically for victims of human trafficking. These have to be victims of severe forms of human trafficking, either sex or labor trafficking, sex trafficking for adults and labor trafficking for both adults and children have to have involved force, fraud, or coercion. Sex trafficking of minors, no need to prove force, fraud, or coercion. They should be US instead of UD. I have to fix this slide. They have to be in the unit, physically present in the US on account of trafficking. And they must comply with reasonable requests for helpfulness in investigation and prosecution. Deepa, do you want to add anything on the T's?
No, but I think there are a lot more T visa eligible survivors of trafficking than immigration attorneys and law enforcement agencies and victim services even identify. And I think there is also, it's really important to understand how there is an intersection even with a lot of times with T visas and family and domestic violence, where you see both children, what we would have thought of not only, but it's child sexual abuse or child abuse, but really qualifies as trafficking as well. And so I think it's important to work with someone who's experienced in identifying so we could serve more victims.
Yeah, and I will just add in a few minutes, we'll talk about it more, but by identifying a victim, let's say who's a victim of either domestic violence or child abuse, who's also a trafficking victim, particularly for children under the age of 18, it opens up a whole world of services and support for them that they wouldn't have otherwise, and that they lose if they don't apply by the time they're 18. So it's really important. And for all immigrant victims of any age, if you're identified as a trafficking victim, your path to benefits, services, and supports is much better than all of the other remedies. Next slide, please.
I think that's me.
Yeah.
So I think the point of this slide is that not only do these immigration protections provide benefits for the survivor, the one who suffered the harm, many of the immigration protection also provide immigration benefits for certain eligible family members. And really, you've got to look, and I'm going to talk later about why you might want to apply for certain types of benefits over others or alternative forms. One of the things to look at is who might benefit besides the survivor. And so this slide highlights kind of just very quickly under each of the types of benefits we're talking about today, which family members can also benefit. And remember, the point of this is to keep intact families together. We don't want to just, provide immigration stable status so someone can remain safe in the United States, but then separate them from their family or their families be at risk of being removed from the country. So it is to make sure that the survivor has the supports they need by being able to petition for their eligible family members as well. Next slide. Okay, so this is our hypo, and I'm going to read it. I know people process information differently, so it's also up there for you to read as well. Bear with me with my voice. So Clara met Eduardo, a legal permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. After Clara became pregnant and gave birth to a baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the U.S. to live with him. When they arrived in the United States, Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel, who tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when he said she misbehaved. Within a year following their arrival, Eduardo forced both Clara and Miguel to work for his family's business and never pay them for their labor. One night when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with the belt of Miguel and of Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors called the police for help. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse and took Clara to the hospital and placed the children in the care of the state. So now you're going to have some quiz questions via the poll. So would you like me to read that for people who might not be able to see as well? So the first question is, what forms of immigration relief would Clara qualify for?
And I'm just going to say there's 3 questions. We grouped them together. So we're going to go through this one. And then if you scroll down, you'll see the second and third. And then we'll kind of go through them all together, if that's okay.
Sure. So you want to read the second question so people know? Okay.
What forms of immigration relief would Lupe not qualify for? And the third question is, what forms of relief would Miguel qualify for? So take some time
And so Lupe is the daughter, Miguel is the son, and Clara is the mother.
Right. And the first 2 questions are a single choice, and the last one is, I believe, check all that apply. Is that correct, Rebecca?
That is correct.
Okay, so you did your homework.
Yeah, so answers are coming in. So I'm gonna give it about maybe 10 or so more seconds. Yep, we're having people answer. All right, we have about 33% who've answered. I'll give it another 5 seconds maybe, and then I'll share the results.
And hopefully you'll see how easy this is to know at least that somebody qualifies for something, and you refer them to IUDA or other places in the state that can help them. Okay.
So let's tackle the questions. So, first question. 69% of you picked all of the above, and you're right. Those who picked U and the VAWA and T were also right. But the best answer was 69% because Clara would potentially be eligible for all those forms of relief. So great job, everybody.
Yeah, and what's I think really interesting to point out here, Clara and Miguel, there's nothing in the scenario about whether they're married. So if they were married, Clara and Eduardo, sorry, Miguel's the son. What's important here is that Clara qualifies to self-petition as the mother of Lupe either way, right? She gets VAWA protection as the mother of an abused child who's abused by a U.S. citizen or lawful permanent resident parent.
Right, and I'm going to discuss a little bit later about while someone might be potentially eligible for multiple forms of relief, there might be additional facts you need or issues to address that makes some ultimately not the best form of relief and other forms of relief potentially more successful. So let's go to the second question, which was, what forms of immigration relief would Lupe not qualify? And she was the baby that we assumed is the biological child of Eduardo, who was brought over but was born in El Salvador. So look, let's see. We have, I guess, not quite an even split, but the correct answer is actually D. Assuming she's the child of Eduardo, she would be able to benefit from a VAWA self-petition because he physically and probably other ways abused her, and she is presumably the child of a legal permanent with a legal permanent resident.
Right.
The U visa, because she was a victim of physical child abuse in the United States, and meets all the other eligibility requirements, and as well as special immigrant juvenile status, as Leslie indicated. And actually, I wanted to point out, in the state of Maryland, what's really fantastic is the legislature actually made it very clear, for the purposes of special immigrant juvenile status, a child is considered in the state of Maryland a child, well, as long as they're under 21, which is like different than family law generally, and they're unmarried. What she's not eligible based on the facts is a T visa. There's no indication in the facts that she would be she was a victim of trafficking.
But she could, if her mother applied for a trafficking victim visa, then could she include Lupe in her application?
Absolutely. And also, depending for the T visa, like depending on age, and I think given the age here, there is sibling beneficiary as well for certain forms of relief.
Right.
So the last one, I want to make sure we don't spend too much time, but what forms of relief would Miguel qualify for? And as Leslie already flagged, if Clara and Eduardo had been married, he would have been eligible for the VAWA self-petition, but that's a big if, right? Well, let's assume if not, then he would not be eligible. But there's facts here, just based on the scenario, that he'd be eligible for the U visa, the T visa, and again, a known fact would be the special immigrant juvenile status. We are presuming, based on the fact scenario, that Clara has not abused, abandoned, or neglected Miguel. So we would need to know more facts about the biological father of Miguel, if he maybe abused, abandoned, or neglected him in some way.
And what I think is important here is that being a stepchild who's abused by a U.S. citizen or lawful permanent resident or by a parent is different for SIJ purposes. So, for example, for VAWA self-petition, if he's a stepson, he's eligible. But if his stepfather abuses him, he's not eligible for SIJ based on the stepfather's abuse. It would have to be his natural father's abuse or abandonment or neglect in Miguel's case. Just to keep us on our toes, right?
Next slide. I think that's you, Leslie, now.
And so you can see that people really could, in this scenario, which is probably typical of things that you might commonly see, that people are eligible for many of these forms of immigration relief. Where they start to differ is how long it takes. So one of the things we know from our social science research is that the really important time in a victim's immigration case is how quickly you can get the case filed and how quickly you can get the victim to work authorization. The moment they get work authorization and formal protection from deportation, their lives begin to change and they become much more stable and secure and more likely to get engaged in the justice system and all kinds of things. And what you see here is that point in time is going to be more than 5 years, up to 5 years-ish for the U visa, where it's 6 months for SIJ, 18 months for T, and 34 months, either 3 or 34 months for VAWA self-petitions. And the difference is whether or not the abuser is a U.S. citizen or lawful permanent resident, how fast you get the work authorization is the key. Next slide. And the next 2 slides are really for I'm not going to talk about them in detail. We have a whole series of webinars, including one I recorded yesterday, on what the Office of Trafficking in Persons offers child trafficking victims and adult trafficking victims. And it's just to say that identifying Eduardo in this scenario as a trafficking victim is super important, because if you would identify him and he gets a referral made to the Office of Trafficking in Persons, within months, he can have a caseworker, access to refugee benefits and services, lots of support. that's available for trafficked children in particular. So you want to do what you can to identify trafficking before the child turns 18. And that's what this slide and the next slide are about. And it has a checklist of, next slide, please. There's a checklist of how the process works. And again, we're going to send you links to webinars and materials on this. Next slide, please. And I think this is back to you, Deepa.
Yes, so we want to ask you all on this webinar today, when a victim comes to your agency for help, how do you approach what to do first? If you could put that in the chat, and maybe Becky, would you be able to call out some of the responses?
Yep.
And we're talking about, like, they have multiple needs usually. So what are you going to do? Immigration first, family law first? How are you going to think about it? You can also say you don't know, and then we'll ask Deepa. Or she'll ask me. Anybody want to chime in? So Deepa, what do you do first?
Well, we have a screening process at AYUDA, then. So I think well, wait, I want to go before I give my response.
Someone said assess
safety.
Someone said assess safety and shelter, and then provide orientation to the criminal justice system. And then someone just said start with gaining their trust.
Yeah,
Excellent.
I agree with that. I think it depends on what agency you work for, organization. So the purpose that kind of probably guides what you do. In a place like AYUDA, which is both we do a lot of humanitarian based. So we do see a lot of survivors who are in crisis, but we also do see family-based immigration as well. So it's screening the client, the prospective client immediately for what their needs are, that, starting with what are they saying they're coming to you for, and then making sure you have trained staff. I think anytime the red flag comes up that they might be experiencing some sort of domestic violence or other harm, a trafficking situation. And I think, assessing for the immediate safety needs and doing safety planning is #1 priority when you identify that's an issue. From there, at an agency like AYUDA, we, once that kind of is assessed, just trying to match or refer out depending on what that service seeker comes to you saying they need. Leslie, any additional thoughts?
Yeah, so next slide. One of the things that you want to, as you go through the safety planning process, part of safety is safety from deportation. So you want to figure out what form of immigration relief they may qualify for and how quickly they can get that case filed. And one of the reasons that's so important is, as I mentioned earlier, the faster they file, the faster they get work authorization. But as importantly, what we know is abusers, traffickers, domestic violence perpetrators, child abusers are out there trying to get victims deported. And what we know is when the moment they file for immigration relief, they're lodged in a system that basically says, red flag, this case is a victim. So when the perpetrator calls up and tries to turn the victim in, DHS is not legally able to respond because they see it's a victim, so they don't do anything. And so it's the most effective way to get that protection happening. So putting on my family law hat, I would try, it's a real hard safety planning question, but do I get my protection order first, or do I file my custody case first, or do I get immigration? If I've got a perpetrator out there threatening to have her deported, I want to try to get the immigration case filed first. So if he tries to retaliate by reporting her, DHS won't act or can't legally act. So that's kind of how to think about it. It's part of the safety planning process. Next slide, please. And so the VAWA confidentiality system I just described is part of the value of filing early. And it gives them earlier access to all of these things. Gio, Commander, from a law enforcement perspective, what do you see as the benefits of people who begun the process of filing?
Sure. Thank you, everyone. I just want to say thank you for attending the seminar. This is critical, especially in a time when we see an increase, a surge of crime, and a lot of police officers retiring. So a benefit to me is, and somebody mentioned this before in the chat, somebody mentioned we need to start building trust. So law enforcement, we want to early on, we want to engage those survivors. We want to tell them who we are. We want the survivors also to have the benefits that everyone has. Just think about a victim, a survivor, not having resources to medical benefits, shelter, work. So this is valuable for the community well-being, for the police department, for the safety of everyone.
Great. Next slide, please. And what's very interesting about it is that when you look at Maryland's U visa statute in terms of certification, there are confidentiality protections that essentially remove barriers. So what the commander was talking about is it helps build trust because people can know that they can apply and that the information will be protected, which is not only consistent with Maryland law, but consistent with federal immigration law as well, which basically bars access to any information about any VAWA confidentiality filed case, except for in all family court cases. And in a criminal case, the only thing that's discoverable is a U visa certification or T visa declaration itself, when it was signed by law enforcement or prosecutor and is in the prosecutor's care and control. Next slide, please. So one advocacy best practice before we kind of dive into a little bit more of all of this in more detail is there's another way to inform Department of Homeland Security that a victim is protected by these no deportation kind of confidentiality laws. And that is, if as a lawyer or an advocate or a child welfare worker, as soon as you identify somebody and you start working with them, you can write them a letter on your letterhead saying this person is in the process of filing a VAWA to your youth. They're in the process the moment you refer them to somebody and start helping them get into the place where they're going to apply. And then they can show that to DHS if they're stopped, and DHS has they can't continue enforcement against them. And if they try, call my cell, and I'm serious, as the commander can tell you. I handle these cases nationally. So if a victim gets picked up who you're working with, my cell number is on all the materials we have. And I work with people in DHS to get them to back off when a perpetrator tries to turn on a victim. Next slide, please.
So
do
you want to ask me the question?
I'll ask you the question. Can or should victims apply for multiple forms of relief? And if so, why?
So I think we've already touched on some of the reasons why, but I want to go a little bit deeper. You know, as I stated before, different forms of immigration relief have different benefits and different requirements. And so absolutely, you know, I come from like throwing the spaghetti at the wall and seeing what sticks, because the thing is, look, people have complicated lives and they might have prior histories that make some immigration relief easier or less easy to obtain. So some of the things why you would want to apply for multiple forms of relief, we already touched on two, I think, that are really important, which are things like how quickly could someone get work authorization? The second, I think we already discussed, is who, in addition to the survivor, might benefit, because different, as we indicated in the other slide, certain forms of relief cover different eligible family members. And so, you know, for example, the T visa in certain circumstances has a broader way of who's considered an eligible family member. So maybe that's the better way to go. Maybe with special immigrant juvenile status, the parent can't benefit, the non-abusive parent can't benefit like through that process. So maybe you pick the U visa where the parent can. It really depends. It's really so fact specific. Another thing from an immigration attorney perspective is the client's criminal and immigration history. You know, people come here on all different matters for all different reasons. Unfortunately, we see a lot of survivors because the circumstances come in without inspection or have other immigration violations or even criminal, that oftentimes it's important to understand if it's connected to the victimization. So it's really important to do a thorough screening in order to assess the viability of the different arrays. And sometimes when it's a little edgy, look, T visas particularly, there's some requirements that depending on the facts might make it difficult. But if I get that for them, the benefits, as Leslie indicated, for public benefits are like immediate, and even while preparing the T, you can access benefits, and the timeline's much better. But I know maybe there's a tricky element. So look, it might be a more straightforward U visa. So if we have the resources, I always say we should be looking at all avenues of relief. But it also goes back with being client-centered, talking with your client. What are their goals? I've had clients say, it's more important for me to include this family member than getting work authorization faster, or vice versa. So it's really important to be client-centered and talk with your client about what's important to them.
And sometimes, like, we're going to be talking really soon now about all the U visas. And one thing I think about in U visas is that where the child has been abused, abandonment, neglect. So you'll have a lot of U visa parents whose children might have been abandoned or neglected or abused by a family member in the home country. So they can be in mom's U visa case while they file for SIJS. So mom will ultimately get her green card through the U visa over time, but the child could get something faster. So there are those kinds of things as well. So now we're going to turn it back to the commander to talk about the U visas.
Thank you, Leslie. Next slide, please. Yes, U visas promote trust. Yes. Just quickly, I just want to say that I spent 31 years in law enforcement, and I retired this year, January 31st. Great time in the police department. And this is my philosophy. We need to start building trust early on. We need to build those relationships. And I'm glad to see the participants today. They come from different backgrounds. If you're going to take something out of here, my advice is build those relationships, exchange information because you're going to need it. But access to justice. Okay, let's talk about that. Just want to say that to be effective, to be a good leader in public safety, we need to keep looking into the future because this world is ever changing. In the Minneapolis Police Department, I'm originally Ecuadorian. I moved to New York City and then I moved to Minneapolis. And when I moved in 1992, we saw an explosion of demographics, especially Latinos moving into Minneapolis. I had the opportunity to oversee the U visa in 2017. And this is another tool used to build trust, to reduce crime. If you look around the nation, and I'll give you a quick example, President Obama task force and building community trust, he talks about, one of the recommendations, he talks about law enforcement agencies should build relationships and trust with immigrant communities. So this is another tool in our box to build trust, to increase our legitimacy, and to reduce crime and bring justice to the survivors and whole offenders accountable. Next slide, please. Oh, okay, so I always like to hear, how did it start? What's the historical context here? So Leslie, can you say what were the Congress goals in creating this immigration relief?
Sure. Next slide, please. So I was actually at the drafting table, and what the conversations were is that they were trying to do at least two or three things. They wanted to enhance victim safety. They understood, I mean, for years, for decades, and the number changes a little bit, but right now, 25% or more, 25 to 26% of the US population are live either immigrants themselves or have one or more foreign-born parents. And when you think about that, that means at a minimum, across the board in the United States, there are communities with lots and lots of families that can't get access to justice and lots of crimes that police departments can't solve and prosecutors can't prosecute, and victims can't get protection. And so the idea was to enhance victim safety, allow victims to help to try to remove fear of deportation, build relationships between immigrant communities and law enforcement, and understanding that that's going to be safer for communities, it's going to be safer for the victims, and we've learned over time it's safer for police themselves, because domestic violence is particularly dangerous when it comes to police lethality. That perpetrators of domestic violence often become the ones that kill police officers. And so there's a lot of ways, there's a lot of reasons why police departments around the country are choosing, and why states like Maryland are choosing to promote U visa certification. And as you listen to Gio talk about it, I think one of the things for the victim advocates and attorneys in the room is, and this is why I invited the commander to talk, because I've worked with him so much. I think how he talks about it from a law enforcement perspective is how we should be talking about it when we approach police for certification. And that's a good way to build relationship and better understand where we're each coming from, so that more departments are certifying U visas, and it's better for all the crime victims and for the departments. Over to you. Back to you, Commander.
Thank you, Leslie. No, and I think that we have a section where we're going to discuss about best practices, and we'll talk more about that.
Right.
Rebecca,
slide,
can we go to the next slide, please? 35. Oh, yeah. This section describes the basic requirements for the U visa. And full disclosure, when I took over in 2017 as the commander of the U visa, I didn't know anything about that. I started reading everything. I started researching across the nation. So I came across NIWAP, and going to NIWAP, they had thousands of articles and toolkits about the U visa requirements. But one of the things that I used, one of my initial tools that I followed was, what is it called? I'm sorry, it's called the U visa Law Enforcement Resource Guide. This document has 25 pages and it's very clear, especially for law enforcement. Google it. And I follow that to the letter. Just follow the requirements. But let's talk about the victim. One of the first things that I do is we look, and I think we talk about the screening process. That is vital. That's vital to have the screening process and have an understanding of where the victims are coming from. So I'm not going to talk much about that, but I did that all the time with any survivor. We do have an initial screening process, and one of the things that all my experience was based in reviewing about 4,000 U visas in about 4 or 5 years. So one of the first things that I do is this victim a victim of a qualifying crime? And there's another slide that's going to show about, I think there are about 26, 27, correct me, Leslie, if I'm wrong, but about 27 qualifying crimes.
Yeah, roughly.
Roughly, about that, yes. And 2, I want to know, does the survivor has any information about the crime? If survivor call 911, I want to know those 2 components. And 3, did the crime took place in the U.S. or violated U.S. law? So that's how I take a look at it. I look at the report. I speak to the victim, and that's my initial entry into whether the survivor is going to qualify, whether they're going to certify this or not. And remember, I just want to say this: there's a big misconception in law enforcement. Just because I'm going to certify U visa does not mean that the survivor is getting a U visa. That's just the first step to a long process. The second one, and as I listened to these webinars in the past 3-4 years, helpfulness is key. There's a lot of misconceptions about helpfulness. And let me spend a little bit about with helpfulness. There are 3 things that I usually look to determine the level of helpfulness. Did the victim have information, either past information or present, or is likely to be helpful in reporting more crime, It's going to help us in the investigation, the prosecution, the conviction, and the sentencing. But I want to make this clear. We do not have to have everything. We don't have to have. A lot of my peers from all the agencies will call me and say, Gio, do they have to provide health in all these 5 areas? No. I mean, for me to make this determination, if you read the DHS resource guides, no. A current investigation, the filing of charges, a prosecution, or a conviction are not required to sign the law enforcement certification. Most of the certifications that I sign, the survivors will do an initial call to 911, or when the officers arrive, the survivor will point out to the suspect. But no, I don't want you to get caught up that thinking that the survivor have to help us in the detection, the investigation, the prosecution. No, it's a very, very low standard. And substantial harm. I'm glad that we have time to discuss harm. I want to make it clear that as a police officer, I do not make that determination. I don't say, okay, you suffer physical, mental abuse. I'm not going to make that determination. However, through the interview process, most survivors, through the attorneys, through the victim advocates, supporters, will provide me with information that they were with medical reports. And sometimes those medical reports can give you more information. There's nothing wrong if you want to attach that information. If you want, there is a space in the 918B in this application where you can make notes that the survivors sustained injuries, saw medical treatment. In most of my cases, I will notice that the reports will say survivor was punched. And then later, I will notice the medical reports that the survivor sustained broken ribs. I mean, these are substantial physical abuse. So this is not part of the certification process, but I encourage you to please note that in the 918 application. Next slide, please. Yes, qualifying criminal activity. I think I talked a little bit about this. I think there are about 27, 29 of these qualifying criminal activities. My time in Minneapolis, let me tell you, I spent a lot of time reviewing and certifying, I think over 4,500 applications, and most of the applications, the survivor was involved in domestic violence, criminal sexual assault, so felonious assault too. I'm going to be talking a little bit about that. Let me see, I just made some notes here. And it's interesting because what happens in Minneapolis aligns with some previous research. I think NIWAP conducted research, and out of the 10,000 applications, I believe that 51% are the result of domestic violence. And as I talk to my colleagues around the nation, I see the same pattern: domestic violence, criminal sexual assault. Something interesting happened during the pandemic. We saw a surge of U visas with domestic violence. We also, during the civil unrest in Minneapolis, we saw also carjackings, robberies. And now I'm mentioning carjackings and robbery because you don't see those crimes here in the list. You don't see it. However, carjackings, aggravated robberies, they may have a felonious assault element there. I'll give you an example. In carjackings, we saw a record-breaking number of carjackings in Minnesota, Minneapolis. We were all over the news. So when victims get pulled out of the car at gunpoint, they may be assaulted, they may be shot. So those are elements of felonious assault. So even though you don't see carjacking here, that very well qualifies. Go ahead, Leslie.
No, just, there we go. I wanted to switch slides because that's what you're talking
Thank you, yes. Yeah. Yes, no, perfect. No, this is about what I'm going to talk. Also, I oversaw child abuse too, and I also saw we had a unit that did full-time elder abuse investigations. So if you go back to the list of qualifying crimes, you're not going to see child abuse. But think about this: the child who's the victim may have a relationship with a suspect, a familiar relationship. So it could be the father abusing the child. So that can go into the elements of domestic violence, could be into the crime of criminal sexual conduct. So we saw those. That was pretty common too. We saw that.
Right, and
And
what I want to say, what you're saying that is really important is you want to check all that apply. And so if you can see within, so first of all, the Department of Homeland Security has formally recognized hate crimes, video voyeurism, elder abuse, child abuse, and aggravated robberies like the context that Commander was just explaining as fitting similar criminal activities. In addition, though, there may be within the child abuse, sexual exploitation that's occurring that you can check also. So you want to check all that can apply so that, because the victim ultimately needs to match up the substantial harm with the crime victimization.
that's a great point, Leslie. Thank you. Especially in domestic violence, we'll see, for example, witness tampering is another qualifying crime that we saw. So we'll see that with domestic violence, we see witness tampering, coupled with possible kidnapping also,
Yeah.
which is another qualifying crime. Thank you, Leslie, for adding that.
No problem. So let's go to the next couple of slides, and because I want to move through, we have a lot to cover. So the person who can apply is the victim of the qualifying criminal activity. It also can be a case in which you have an indirect victim, which could be like the parent of a child. So the child's abused, and or the parent or a family member, the parent of an incompetent or incapacitated person. And then children who are victims can also have their next friend or a family member provide the helpfulness. Bystander availability is extremely limited. We can give you a lot more on that, but I think we don't have time today. But basically, the best example of this is there was a case in Virginia. This is actually in the regulations, where they were having a birthday party and a domestic violence case, and the husband came and tried to shoot his wife. There were a bunch of people outside. He shot some other people. One of the people attending the party was pregnant and miscarried. And that victim, that person who wasn't shot, but was pregnant and miscarried because of being a bystander, that qualified. But that's kind of how to think about it. Next slide. Gio.
Thank you, Leslie. Yeah, and who can certify? That's critical too. One neat thing that I'm very proud of Minneapolis, we put together a working group. The working group were made out of judges, county attorneys, city attorneys, diverse number, not only law enforcement, but very diverse working group. And most of our community partners did not know who was the certifying official. There were misconceptions that only law enforcement can certify. No. As you see in the list, there are a number of agencies. In Minneapolis, we have county judges, the county attorney's office, the Department of Labor can certify. We also have in Minneapolis a civil rights unit within Minneapolis. They also can certify, but not only, this is not limited to law enforcement or the county attorney's office, the judges, and be aware of this list. This is a helpful area where you can start building those relationships and educate the judges and the potential certifiers.
Great.
Thank you.
Next slide, please. And judges can also certify. Judges, magistrates, commissioners, judicial referees, all kinds of judges. We're going to do another quick poll. Next slide. Why might a victim seek certification from a state court judge? We have this poll, Rebecca? There we go. And so there's your choices. It's a multiple choice. The judge might be the only justice system contact in a custody or a protection order case or a civil employment child welfare case. You might have a situation where local law enforcement didn't do a good job with language access on the crime scene when the victim called for help. So the first person the victim is communicating it with as a qualified interpreter is the judge. Maybe the police didn't investigate the case, or the prosecutor, the case was never sent to the prosecutor. So you might have a police department that should be certifying but isn't, because as the commander was saying, if you detect the criminal activity through the police, the 911 call and meet that low bar, Whether there's an ongoing investigation shouldn't matter. Or maybe the judge observed the victim's attendance and participation in a criminal case. Rebecca, how are we coming on our poll?
We have about 35% of participants' responses so far.
Okay,
I'll give
shall
it
we
about
look
10
at
more
the
seconds.
results?
Mm-hmm.
And yes, it looks like 30 to 50% of you agreed with some or all of these, and that's true. These are all reasons why judges may be called upon to certify. Next slide, please. So let me explain why Congress designed the U visa to authorize multiple agencies to certify. People think, well, were you trying to set up foreign shopping or something? And the answer is yes. I mean, the goal here is Congress wanted victims to seek help from the justice system. And so they opened every door they could imagine. And the idea, because you never know which door a victim can walk through in which communities. And we were aware that there may be communities where prosecutors are trying to wait until the end of the case to certify, or where law enforcement isn't signing certifications, even though they're supposed to under state law. I mean, and so we wanted to, that's why we designed it that way. And then when you look, and so I'm now going to turn this over to Deepa to talk about the Maryland statute. Next slide.
Hi, everybody. So Maryland in 2019 passed a law that addresses U visa. A lot of it mirrors the federal law, but there's like nuances specifically. And so I think what's a little bit more specific than the federal law is under the Maryland U visa statute, it specifies things like the Maryland Commission on Civil Rights, the Maryland Department of Labor, which, to be frank, under the federal law had been in that kind of context, those are agencies that arguably had certified, but with some advocacy. So I think by the time 2019 came around, that's like 19 years after the U visa law was passed, there needed to be some clarification. And it's important to understand there were some motivations behind that, because the question is, why would you need a local Maryland law addressing U visas if there's already a federal law? Well, there were some, issues with implementation, need for clarification. But from an advocate perspective, I think one of the biggest challenges for me were that we were having kind of two major issues, right, in Maryland. Depending on where you were, the attitude and understanding of law enforcement, whether there was a desire or lack of understanding that they could certify was an issue. So it wasn't fair. Like if you were in Baltimore City, but if you're, say, in another where you could get a certification, but maybe you were in another county with a specific agency or the whole county, and you were unable, the response was, we won't certify, or we don't certify, or we don't think we have to. So that was one major reason. The second one, frankly, was, we're going to talk about timing requirements, is that at one point, it took me over 15 months to get a signed certification in Baltimore City, which something I had never had a problem with, but I saw over time, and I've been practicing specifically in immigration law from September 2006. So I'd seen it get worse and worse over time. So there, a lot of advocacy was happening to make sure this wasn't happening, because it puts victims' lives at risk. As Leslie indicated, there's a lot of advantages for filing early and quickly once you encounter a survivor. So what the law does, which is fantastic, is it does require those who are authorized to certify U visas to complete their request or deny it. So basically either sign it or deny certification within 90 days of the request. Additionally, if the person is in removal proceedings, so they're actively in immigration court proceedings or subject to a final removal order, the agency has to make a decision within 14 days. Okay. And there's also some detail about what should be in the certification, details about the criminal activity, victim helpfulness. In copies of documents that approve, I should say, I would think substantial abuse, because that's what the element is. And to Gio's point, look, law enforcement, that's not their job to determine whether there's substantial abuse as vis-a-vis meeting the eligibility requirement under the U visa law. That's for USCIS to determine. We're just asking law enforcement to decide whether or not the person was a victim of a qualifying crime, and whether or not they are likely to be helpful or is being helpful. So the Maryland visa, statute emphasizes these things, but I think the biggest things is this timing, because it became a huge barrier. And also Gio indicated, his colleagues asking whether a victim had to do specific things. No, and so this law makes clear, because there was a lot of questions like, can I sign or not, because they didn't do X, Y, or Z. It doesn't require even having a current investigation. It doesn't even require a filing of charges or a prosecution or a conviction or testimony. And I've seen this in cases where it was a stranger way. They gave as much information as they could, but it wasn't going to it didn't even lead to much of an investigation because of the nature of the crime. And so, yes, you can certainly, law enforcement could sign and did sign a U visa certification for that case, and that case was ultimately successful. So I think that's important. One of the things I do want to address in terms of who can be a certifier, I think it's still a bit controversial. In the Maryland U visa statute, it does say law enforcement agencies and those who are authorized to detect, investigate, prosecute, convict, and sentence, right? So what it doesn't say specifically is the word judge. And so I think there must have been some controversy around that, because in August of 2023, just this past August, the Maryland Ethics Judicial
actually, Deepa,
Yeah.
I don't think we need to address that. That is in the process of getting revised. So let's not address that. There's really good work happening in Maryland regarding judicial certifications, and I've been doing training with the Maryland Supreme Court on this for a number of years now. So I think,
so my point was actually specifically that the Maryland Judicial Ethics Committee issued an opinion making it clear that judges can and should, where appropriate, sign U visa certifications.
right, and that
was the point of that.
Right.
So in terms of an advocacy point, I just want to make it clear there you have got the legal tools, and we'll probably discuss that later. But if you are encountering some resistance, there are powerful tools you can point law enforcement and judges to make sure they understand that not only are they empowered, but that they should under Maryland law. And using that Maryland law, what we often do as advocates, when we're making that request, we will cite it in a friendly way, especially if it's the first request. We'll cite it in a friendly way, citing the law and saying per blah, 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 you're authorized to do that within 90 days. We're requesting within 90 days. I would add this, if you're going after for a judge's signature on a cert, I would add this Maryland ethics opinion, making it very clear they can and should. If you have to go, and I think it's about enforcement, if you've got to do a second, I think you then kind of start using that hammer and say you're required to. So hopefully it'll be in the resources, and also the law is linked there. But I think advocates should be using that to make sure they get law enforcement to sign. And
we fully expect there'll be much better direction from the Maryland courts statewide in the next several months. So that's where you will be receiving some direction in a way that will improve it as well. So, and then what's also important is, by and large, what I think is where people get kind of confused at times is that, and the commander said it earlier, is that generally speaking, law enforcement, prosecutors, and judges, when they certify, almost always are certifying based on what the victim is doing now or already previously did. It's or. So they don't have to predict the future, and they're not being asked to predict the future. Most of the time, certification is based on what the victim has already done. Next slide, please. So if you have sought a how many of you on the call, there's a raise your hand function at the bottom of your screen, have sought a U visa certification since October 2019 from one of the agencies listed in the statute and had your U visa request denied? And how do I see the hands? Do I go to participants?
I think we see them if you go to participants and if they raise their hand.
Yeah, anybody? The good news is I'm not seeing any.
I'm
Which
not
is
seeing any.
Excellent. So next slide, please. Well, if we're not seeing it, we can skip the next slide. If any of you had certification requests denied since that date, could you type the counties in your chat? And I'll just move this kind of along. And hold on one second. I'm trying to find the everyone thing. Okay, and next slide. Have you had problems attaining certification? Anybody want to share some problems they've had that they would like to have addressed by the speakers during this webinar to be sure? And what I'll do is go ahead and type those if you want during the chat, and I'm going to, while we're doing that, I'm going to turn it back over and ask a question to Commander Velez. Next slide, please. How does U visa certification help law enforcement and victims? I mean, I know you talked about this a bit, Commander. Is there anything you'd like to add at this point?
I just want to focus again, building that relationship, bringing justice to the survivor, holding them accountable, but also safety to our police enforcement. During the pandemic, we saw a surge of domestic violence with the link. And let me be clear. So the domestic violence, when we will respond to arrest the suspects, suspects will fire up on law enforcement. And we saw that across other neighboring jurisdictions. So we want to be able to bring those offenders accountable through trust building, through justice, provide safety to the safety of the community and law enforcement. And once again, at a time when we lost police officers, crime was up. Don't we want everyone in the community involving through trust, involving reporting crimes, encouraging others individuals to report crimes? So I'm going to leave it at that because I think we talk excessively about this. Next one, if I need to do the next one.
That's my next slide, please.
Okay.
So what is really important to understand, and this is something, again, if you're in a community where you're working with law enforcement, you're trying to build a relationship with law enforcement, with prosecutors who may be either not certifying or delaying in certifications or have questions about certifications. This is data that I'll share with you in the materials that we're just distributing. I'm writing my note. And what we found is that once victims get certification and then they get to the point in their case where they get work authorization and deferred action, there's 114% increase in their willingness to trust the police. U visa victims 36% of them may continue to make future police reports about future crimes. And 22% of them reach out and help other victims in the community come forward and get help. We also see declines in immigration-related threats and abuse, declines in child snatching threats from the perpetrator, and the declines in trying to use immigration status as a weapon in family court. Next slide, please. So as a certifier, to what extent, Gio, are you, when you're determining helpfulness, you told us a little bit about it. Are you ever really thinking about future helpfulness? Is that a factor in what you're doing, or what kinds of things are you basing it on?
Absolutely. And I think I discussed a little bit about helpfulness. And once again, thanks for this opportunity, because that's something that law enforcement, they are confused, there are misconceptions. So this is a good time to make these clarifications. Can we move to the next slide, please? I believe there's
Yeah, should be a next slide. Melissa,
okay. So I just want to mention that this is great when I see this not only DHS has a philosophy of trauma-informed, but we all should approach contact with victim survivors with this philosophy. And when I mean trauma-informed, victim-centered approach, I'm talking about the ability to have some empathy with these survivors. And that's going to pay dividends, I believe, especially to combat, to reduce serious crimes, and to bring offenders accountable. I believe that when we are doing this. We have moved from years of holding or kind of interrogating the victim to being more understandable of the trauma that the survivors are going through. So one thing that we do not do is we don't ask victims, oh, why didn't you call 911? Why didn't you get a protection order? In Minneapolis, we have tremendous support our victim services programs. As a matter of fact, we have victim advocates embedded in the police department. So we want to do this we want to bring stabilization to the victims. Survivors are not thinking at that time about testifying in court, but they are thinking most about, what am I going to stay tonight? Where am I going to stay tonight if I got kicked out of my house? How am I going to go back to work? My safety, food, shelter, medical. How am I going to see medical support for my injuries today? So having this victim-centered approach, once again, is going to pay dividends, bringing justice, our image, improving our legitimacy, building that relationship, and safety for everyone. Next slide, the next one, please. Okay, detecting helpfulness. And thank you for allowing me to say this. So in the past, like I say, one of the things that I look at is, has the victim or victims, do they have information? Do they have it right now? Or will they have information about the suspect? That's how I determine helpfulness. And I'm not looking into, and most of my 4,500 U visas that I certify and I review, I will review reports, I will review phone calls, I will review medical reports, and technology plays a key role, and this is for law enforcement. I will also review the officer's body-worn cameras. And sometimes, because of the language barrier, officers are not able to capture the whole story. So through the use of technology and through the interviewing, people will determine that if the victims will call 911, either point out to the suspect, either providing me with information about an order of protection, medical reports that show injuries that equals to a felonious assault, I will determine that. Remember, it's a very low standard, just like Dr. mentioned. We don't have to prove or disprove, thank you, that the victims call 911, that they submitted through a sexual assault kit, that went to the hospital, that they filed protection orders. I will determine, did they call 911? I want to quickly give an example, Leslie, here. We had an individual who has been doing robberies at McDonald's. This happened about 10 years ago at McDonald's. He went into this McDonald's. A survivor was working there. This individual had a gun, put everybody at gunpoint on the floor. The survivor ran into a bathroom and she called 911. When the officers arrived, because of the language barrier, they never interviewed the survivor. Through the use of technology, we were able to pull the phone call and listen to the victim, calling 911, giving a description of the suspect. So it's beyond calling 911, it's beyond reporting. We do have to do some of the legwork also to prove that the victim, in fact, cooperated and was helpful.
Great. Next slide, please.
And thank you so much. I want to say, remember, we are not required to expect that the victims, they are helping through the conviction process, that charges have been filed in court. No, I will certify and sign petitions as soon as I knew that they filed a report, as soon as I knew that they made a phone call. It's a very, very low standards. do not get confused, do not get stuck. And if you look at the DHS U visa resources for law enforcement, they tell you right there, we do not have to wait for all these factors to be completed. We can sign the 918 when the victims call 911.
Great. Next slide, please. So I'm going to actually speed up a little bit here because we've got about 9 minutes to go and there's some other things we want to cover. And I just want to say another point of confusion is, so we've been talking about helpfulness. And again, if they've called 911, if they've offered helpfulness, if they've gone to court to get a protection order, if they've, attended meetings with the prosecutor, showed up in court, all of those are helpfulness. Once somebody files a U visa, they also have an obligation to continue cooperating. Now, we look at social science research and we know that between 70 and 90% of U visa victims actually do cooperate over the long run in these cases. And the difference between the 70 and the 90 is the untested rape kit, or the case where there's no case going forward to cooperate with. And there's an exception. So even though they have to cooperate in the future, they can prove to DHS that their failure to cooperate wasn't unreasonable. The perpetrator was holding them hostage. They were threatening their lives, their families members. There's lots of different reasons. And DHS is required to look at the totality of the circumstances. So next slide, when you're evaluating whether it's reasonable, they look at the totality of the circumstances, the nature of the victimization. And so generally speaking, no certification should be denied requests based on because the victim started cooperating and stopped. That we expected when we wrote the statute, which is why over time, when somebody goes to get their green card based on a U visa, they have to show they cooperated or explain why they didn't to DHS. It's not a reason not to certify. I'm going to go 2 slides forward. So, Deepa and Commander and Gio, how do law enforcement and prosecutors and victim advocates build the kind of relationships they need to approve certification?
Let me go quickly, and I'm going to add 2 strategies that we did. Number 1, invite other community partners. Do the same thing that we're doing here today. Bring experts from different sectors of the criminal justice system. And we used to hold quarterly meetings. Now we do monthly meetings, and continue attending these webinars, gain more knowledge and share this knowledge. 2, we went down to where the immigrants, vulnerable populations frequent. We partnered with faith formations. With the churches. We brought attorneys. We brought attorneys to actually talk about the U visa. And third, one thing that we did and was very successful, we created educational workshops. We call this Citizens Academies. For 7 weeks, we'll train our immigrant community members to learn about the criminal justice process. And we also taught them about the U visa certification. Lastly, I think that these are examples of cultural competency. Learn what are the needs. Let's go and ask them, what is it that you need? Thank you.
So I have an advocate perspective, and I think doing this for 18 years, I've seen such a big change, the openness of law enforcement. Commander just described being open to collaborating in partnerships. So I think from my perspective as an advocate, it's communicating, educating, and then advocating. So kind of the way I see that happen is similar to what Gio is saying. Offer to do trainings if you're an advocate and you represent immigrant survivors, approach law enforcement agencies, being willing, approaching them saying, I'd love to do a training on U visa certification and the U visa and the T visa. Go out to their agencies if they're open and willing. Sit on, like in Maryland, we have domestic violence coordinating committees in most counties. So that's one place where I used to sit on several, where I was able to make relationships and then ask, can I come out and do a training and share with you what the purpose of the U visa and how that will help you make our communities safer? And then look, as an attorney, that's where my heart is, where you need to advocate, you advocate. And so using that Maryland U visa law to make sure that you're getting the response times that are appropriate and that they're complying with that law in order to make sure if your client was helpful and is a survivor, that they should get that U visa certification. So I think it's really a partnership together and being open to having that conversation.
Great. Next slide, please. So I'm going to now talk just very briefly about just to some highlights, and that sometimes prosecutors will delay or want to delay, and they'll believe that if they certify early, it's going to make their criminal case harder. And in fact, next slide, that is not true. And that we have all kinds of training tools and prosecutor trainers involved that can help train prosecutors on this. And that essentially, basically, prosecutors shouldn't be afraid of certifying, and they should know that if they sign a U visa certification, it doesn't mean that the entire case file of the victims is discoverable in the criminal case. Only the cert is. And sometimes the prosecutor should be wanting to structure their case because the victim was targeted because of their immigration status, or because the perpetrator thought they were going to elude prosecution because they chose to target a victim. There's lots of ways that prosecutors can raise the immigration status and not be afraid of it and win cases. The next slide talks also about a strategy that has been next slide, please, very successful in a lot of prosecutors, and that is most victims, when they call 911, have no idea what a U visa is. And so prosecutors are being very successful in bringing prior consistent statements into criminal prosecutions and winning criminal prosecutions when defense counsel tries to say she made up the abuse to get a U visa. Next slide, please. Okay. And so how do relationships with local prosecutors and police, how can that help trafficking victims?
Thank you, Leslie. I'm going to do it quick. This is key. And I was very fortunate as the head of the Special Crimes Investigation Divisions, and that oversaw domestic violence, sexual assault, sexual crimes, human trafficking. We had investigators embedded with our state, with our federal agencies, with our local agencies. So we developed that relationship through the years, meeting with them. As a matter of fact, they are very knowledgeable about the U visa. So we have few cases when they were not available. I did an average of 2 T visas that deals with human trafficking victims, but having those open channels of communications, that trust with each other, we were able to quickly expedite those T visas.
Right. And the other thing, next slide, is that those kinds of relationships also help trafficking victims get something called continued presence, which speeds up their access to benefits and services and work authorization while their T visa is pending. Next slide, please. And we are coming to the close of this webinar, and these are the agencies that actually file continued presence. Next slide, please. And what I'm going to say is that, as we mentioned in the beginning, if you could go to the second to the last slide, that would be useful. We have a whole bunch of materials available for you on the website that you'll see about public benefits access. One more before this. And we have a public benefits map, but I just wanted to show you, I know this is a lot of information, but this is like a little checklist. So as to public, if you can get certification and people get U visas and start filing T visas, and you identify SIJS and VAWA self-petitioning children and adults, all of those in Maryland will give you access to greater access to public benefits and services. TANF, food stamp, so TANF is cash assistance, food stamps, healthcare, education, all of those flow from this. And so we really do want you to take what you've learned in this webinar and build the relationships you need to get to work with your local police and prosecutors, with your child welfare agency, the Department of Labor, all of the agencies that can certify, and certify U visas in Maryland to get those certifications so victims' cases get started and they get the benefits they need. Next slide, please. And that the material will be available on this link. We will send you the link by email to get a copy of the PowerPoint and the material and the recording. And you can always call us for technical assistance. And is there a slide for Ayuda as well coming next? And we thank you. And you can call any of us for further information, and we're here to help. Commander and Deepa, last words?
Just thank you for all the work that you do for the communities, for the survivors. Thank you so much. Appreciate it.
Same thing. Thank you so much for all you do for survivors. And my email is available. I'm happy to chat through any technical assistance as well.
Thank you, everyone. As Leslie said, we'll be sending out this recording, the slides, and all of the resources. Leslie has a very large list to send, so thank you again for joining us today. We do have an upcoming webinar I'm going to send out actually shortly for agencies that actually certify for the visas, and that'll be on December 13th from 1 to 3 p.m. So be on the lookout or share with your contacts when that is posted.
Great.
Thank you, everyone.
We also believe we're going to be doing another webinar with Ayuda on language access. So
yes, working on that.
Thank you so much.
Thank you.
Deepa and Gio, can you stay for a sec? And Rebecca, can